Good morning, everybody. My name is Jim Acting. I'm the chair of this committee. Do we have anyone on the phone?
I believe Meredith just checked in.
Yes.
Okay, good. Am I too loud? Well, welcome again for being here just before Christmas and giving us a little bit of your time. We have one new member today, Professor Dean, I guess, Stevens. Can you tell us a little bit about you?
I've been practicing law in Southern California for about 30 years. My primary practice area.
I'm sorry, Dean, could you hit your microphone?
Yeah.
Thank you.
Is that on there? Could you?
Have it twice.
There it goes.
Practiced law for 30 years in Southern California, based in Orange County. My primary practice area has been advising nonprofit organizations of every variety, and also had a academic career along the way. Taught constitutional law and jurisprudence, interspersed with administrative duties. Was the dean of Trinity Law School for 6 years earlier in the decade, and then took a 3-year break, went back to the classroom, and have been back in the dean's office again for the last 6 months. This will probably be about a 2-year stint for me. But that's the short biography.
Okay, well, we're glad to have you here with us today.
I'm glad to be here.
Again, I think everyone here is Beth Meredith. And the next I have to call for public comments. Is there anyone from the public who wishes to make a comment? Seeing no one, I'm going to close the public comments at this time. Did they tell you we're all being webcast and so being watched?
Yes.
Okay, you can turn your mic off when you're not talking.
It's on.
So that deals with open session number 1. Chair's welcome and call for public comments. We'll now move to number 2. The business A is discussion of moral character, rehabilitation, and remorse, and comparing and contrasting California and other jurisdictions. You, David.
Thank you. Let's see. Oh, good. It's up there. So as we've done in the past, we focused on a few topics, and actually it's just a couple today, and talked about how the topics are handled and reflected now in the moral character statement that's on the website and the factors that are used to determine moral character. And then we looked at some other jurisdictions as well. There we are. So we are in the final list of topics. We got rid of aggravating and mitigating factors. We initially had it listed there because it seems like it'll be covered in the matrices that the working group is working on. And we think it's just sort of not its own standalone issue, really. So currently, rehabilitation, and a lot of this is review. We talked about rehabilitation, I believe, at the very first meeting of this working group, when we talked about In re Glass and Gossage and Mena. Currently, in the statement, it says the committee shall exercise its discretion to determine whether applicants have produced overwhelming proof of reform and rehabilitation. It's pretty strong language. And the nature and extent of the voluntary rehabilitative activities it refers to. In the factors list, it says the following factors, among others, assist the committee in determining whether an applicant has demonstrated rehabilitation from an act of misconduct or moral turpitude. And that list, that contains things like age at the time of the misconduct and how long it's been since the misconduct. It's sort of, sometimes we refer to it as aggravating and mitigating factors. Strictly speaking, some of them aren't exactly, but they really are just sort of factors to consider when making a determination whether there's been sufficient rehabilitation from any specific act of misconduct. Other jurisdictions simply refer to evidence of rehabilitation without a lot of detail. And then, as we've done in the past, I grabbed a quote from one of the Supreme Court cases. There are plenty of them because the court talked a lot in the 3 cases I mentioned about rehabilitation, but this is one of them, where there have been serious acts of misconduct. An applicant must establish, quote, a compelling showing of rehabilitation and truly exemplary conduct over an extended period that would suffice to demonstrate his or her fitness for the practice of law. And we drafted text that may be used by the working group in the guidelines or whatever documents come out of this working group. And the way I tried to capture it is, no act of misconduct is an absolute bar to law licensure in California. Past misconduct, however, requires a showing of rehabilitation that is commensurate with the seriousness of the misconduct. Accordingly, serious acts of misconduct require, quote, a compelling showing of rehabilitation, truly exemplary conduct over an extended period, close quote. Demonstrating exemplary conduct typically includes both refraining from further misconduct and engaging in affirmative rehabilitative acts, such as making appropriate amends to any person or entity harmed by misconduct, performing community service, or taking relevant legal education courses. We see applicants now who will, take MCLE courses in relevant ethics areas, areas that are relevant to the misconduct they have, to try to demonstrate rehabilitation. And the court has said that that sort of thing is important. So that's rehabilitation. I mean, there's a lot to say about it, but that sort of captures it in a nutshell. The other topic I looked at is remorse. It's not mentioned in the moral character statement. And then in the factors, it simply states, it should be noted that the testimony of character witnesses alone will not adequately show rehabilitation, nor will the applicant's statements of remorse. Other jurisdictions, it was not mentioned in most of the ones we looked at. In Colorado, Colorado talks about insight, essentially evidence that the applicant has acknowledged the conduct was wrong and has accepted responsibility for the conduct. And then Texas explicitly says evidence of genuine remorse and recognition of personal responsibility for past misconduct is relevant in their moral character determination process. And so I grabbed a quote. This is actually a discipline case, if memory serves, but it's relevant in this context. And it says that remorse does not demonstrate rehabilitation. While a candid admission of misconduct and full acknowledgement of wrongdoing may be a necessary step in the process, it is only a first step. That is a quotation. And don't let me leaving out the quotation marks fool you. And then, so the simple statement that I came up with is, remorse alone does not demonstrate rehabilitation. I think it's important to, let folks know that. However, a candid admission and full acknowledgement of wrongdoing often is a necessary step in the rehabilitative process. So that is it. This is a list, as we've done at past meetings of the working group, of the sources for the other jurisdictions' information. And I think that's it for me. Just a brief description of rehabilitation and remorse today. Not as many topics as the other meetings. Oh, Larry. Thank you.
So this is one topic that I think is really tough to nail, because it's really about getting inside the head of the applicant. And that's what, that's the part of the whole moral character process that makes me the most uncomfortable, because I think that the bar as basically an arm of the state is probably not, we're not shrinks, we can't get in these people's heads. So I'm just wondering what kind of discussion of that, I don't know, I would just like to flesh that out a little.
Well, I think that, and part of what makes this working group exciting is we are attempting to the extent possible to move toward looking at using objective, transparent criteria during the process so that, because you're right, we're not mind readers. And, you know, in the case of remorse and rehabilitation, but remorse maybe specifically, which is sort of encapsulated in rehabilitation, you know, maybe it's the kind of thing where the working group would want to think about the objective indicia of remorse, so that you don't have to read somebody's mind. You know, somebody who, not being compelled by a court, for example, who engages in affirmative rehabilitative acts, you know, apologizes, pays restitution to victims, things of that nature might be an example of objective, you know, signs of remorse. But I think we should be thinking about making this as, you know, objective as possible. I don't know if anybody has thoughts.
Yeah, rehabilitation is, you know, even if it's court ordered, I guess, you know, if they satisfy that, then I guess it's okay. But, you know, my participation in the moral character interviews that I used to do was I really learned that a lot of it's about acting. You know, this famous line from Louis Mayer, I'll quote it, I'm from LA, so I can do the Hollywood quote. You know, it's all about sincerity. You fake that and you got it made. And, you know, I've seen that. I've seen people who are really good at acting remorseful, whether they're acting or they really feel remorse, and they get a positive review from the panel. And then I've seen people who may or may not be remorseful, but are just, you know, closed. It's their personality, they're nervous, whatever, and they don't come across very well, and they don't get a pass. And I sometimes wonder, is this fair?
You know, one thing we talked about at the informal conference training, sort of interviewing training that we did for staff in preparation for the rule change, was present research that shows how terrible people are at judging credibility. And that's exactly true. And it could be the result, we both know, having been in those conferences, if somebody has counsel, they're often more prepared and they use certain phrases and words that they know will possibly benefit them. But yeah, even the research I've looked at says basically even the very best among us at judging credibility are only accurate, it's a coin flip, like 50% of the time. And that's another reason why, you know, I think we should lean in the direction of objectivity, even though ultimately there's always going to be a subjective element to the determination.
And I think that's the purpose of the matrices themselves, is to help, you know, have some guidance for staff, for applicants, for law schools, as well as for those, as well as, you know, on the credibility part of it. One thing that we talked about, we had OGC there, we had OCPC there, is, you know, diving deep into some of those questions. So somebody says, I do community service. Okay, can you tell us when, how often, what? And so it's not just taking that statement at face value and then potentially the acting is that they can provide, you know, more description, more details, then I think it's more likely that they are participating in it and doing what they're saying.
I have a question. Sure. What about the people who maintained that they were not guilty, even though they were convicted of a crime or entered a plea of guilty because it seemed to be the better way to go? They were afraid of the consequences should they not do it. They're not going to be remorseful if they're telling the truth about all of it. What do you do with situations like that?
There's a Supreme Court case right on point. I can't remember the case, but it's a moral character case. And it was, I can't remember the facts, but the idea, the holding essentially was part of it, that, you know, forcing somebody under duress, coercing them to accept responsibility for something they didn't do, sometimes denying having done the thing is not only not a sign of negative moral character, but it may be an affirmative sign of good moral character because one's being truthful. And I think, you know, it gets down to a factual assessment, I suppose, you know, again, trying to remain as objective as possible. and looking at evidence, preferably documentary evidence above all, perhaps, and then testimonial evidence rather than just sort of trying to assess the person's demeanor or something of that
All
nature.
right, but how can you accommodate that sort of a situation in the matrices by putting in something objective in what it is that we want to provide people who are making these decisions?
Well, that's a
Anything?
good question, and one that, we should toss around for sure.
When we spoke with the director of the parole board as well, this is something that they struggle with in their hearings as well.
Yeah,
And what do they do?
it's like the guilty plea conundrum, for somebody who's actually not guilty.
What do they do? Did he give you any?
I don't think she was able to give us any, that they don't have any bright lines on that either. I think it was just, when we were discussing it, was something that she brought up as a challenge that they face as well, and they don't have a go-to.
Maybe one way to deal with this is recognizing the difficulty of the fact that it is subjective and squishy and all that stuff, is to find some way to mitigate or de-emphasize the importance of this particular factor.
Yeah, it's possible. I mean, I think that sort of thing could be built into guidelines, and the working group, I suppose, should think about whether in that right column of each matrix, what sort of effect accepting responsibility has. I think that's probably partly also what the court was getting at, when it said that remorse alone, does not demonstrate rehabilitation. That's sort of a de-emphasis. But yeah, maybe it's in the right column of the matrices, where that kind of thing would go, possibly.
Debbie?
Yeah. I think a way that might be able to de-emphasize, and I said that in air quotes, you're going to have to look at totality of circumstances. So this could be a factor of many that you're going to look at as an objective factor. Do they show signs of remorse or not? And then you're going to look at, well, why are they not showing it? And what are the objective, here's the documentary evidence, why they did what they did or they didn't do. I think taking remorse alone poses a much more complicated factor than what it's really going to be. And it's going to be a totality of lots of circumstances. So it's not so troublesome to me, and I also think that it's probably less squishy when you are able to make it a factor, not just the factor, as the case law said, first step, or maybe something to consider, or not at all.
Is there room for general comments, or is the entire output going to have to end up in a rule? Like, is there a parallel to like the UCC where there's general comments that clarify the language?
Sure. Initially, I think we were sort of envisioning guidelines, a list of guidelines with, maybe a little narrative sort of supplementing certain guidelines that need to be fleshed out a little more. And then we kind of shifted to this matrices model to really try to make the decision making, have it done within a framework that guides it. But that's not to say that there can't be that sort of guidelines document also. Part of this, I don't want to punt back to the working group, but part of it will be what you all decide.
Some of this seems like it would be well suited for a lengthy exposition. Like, it'd be really helpful to know that in defining remorse, what is taken into account are those situations where the person resolutely feels they didn't commit the act and they've acted in a manner that's consistent with that. I think that's helpful for the interview, but it would take so much text to provide that guidance. It would be unwieldy if it was raised up to a higher level. Otherwise, if you suggest that remorse, in a few words with a bullet point, that remorse incorporates those who said they did no wrong, that's going to encourage everybody to make that argument, even if it's not relevant to them. Or on the other hand, if it's along the lines of the interpretive data like the UCC has, I think that's helpful in determining if there are circumstances where the definition of remorse needs to be moderated, given the circumstances where the person has never taken the view that they did anything of which they were accused.
I think that makes sense to me, and I will say that as far as, the ability of people to deny wrongdoing, in the vast majority of, the cases, how are you going to deny the DUI that you blew the .24, and we have the police report and you went to jail, and, most of the applicants, there's very little question about the sort of fundamental factual basis of misconduct. Not to say we shouldn't have these discussions, because there are edge cases that are important to address, but and it, not only would the person have to have the ability factually to deny it, but they would also have to have the moral character to lie, and hopefully those two things won't come together too often.
David, I would just say that while they may not happen very often, I think they tend to happen though in the more serious cases. And that's where it's harder to demonstrate moral character. There's a higher standard. And so that's why, for me in particular, it's an important thing. I was gonna say that with the parole board, one thing that individuals who are going before the parole board in California do have though on their side is that they do meet with the forensic psychologist before they go to the board. So the board has that information when they're, so that gets at some of the squishiness that then the parole board is not having to sort of process. I wonder if also the word remorse is difficult and that a better word might be accountability. And I think see those things maybe a little bit differently, and that I think we're looking for people to take responsibility or take accountability for their actions. That to me feels what's in line with like a review of someone's moral character. And maybe that helps us move away from some of the squishiness.
But there's also the fact that different kinds of acts, your expectations of remorse would vary. Like if somebody had a couple of DUIs in a short period of time and then didn't have any for 30 years, one's expectation of some kind of penitential attitude is going to be less because you've got everything objective you want. If somebody's not had a DUI in 30 years, there's a reasonable implication they're going to do better. On the other hand, if it's a financial impropriety, you'll never know whether the person didn't just weigh the risk, lost once, and given their license, will take the same risk again and view that as just the cost of doing business. And there, you've always got reasons to be suspicious of remorse. That just seems different in kind from the DUI situation. And again, an area where explanation of what's expected for the attitude, I think, requires a lot of text, not a brief summary.
Potentially, although, yeah, I mean, sort of the math, if you will, I shouldn't use that word because it's never precise math, but of rehabilitation is time plus, rehabilitative acts. And I think it's certainly the case that if somebody had 2 DUIs 30 years ago, the time part of that equation, is obviously important enough that the affirmative rehabilitative acts in that case probably aren't as important. That might be able to be captured in, for example, let's say under the part that has to do with criminal history and DUIs, maybe there would be something in the matrix that would say, in the aggravating and mitigating circumstances column, that would say something like, no DUIs since 1985 or whatever. Something of that nature might be able to be captured there. But again, I'm certainly not opposed to having an additional document that fleshes these things out more.
I like the idea of the accountability / remorse, so they can kind of weigh back and forth. Sometimes even if it's a DUI and nobody got hurt, do they understand that driving under influence is a serious act and you put people at risk? Just because somebody didn't get hurt that time, it's still a very serious thing. If they say they didn't commit the crime, do they acknowledge the crime itself was a serious crime? Do they acknowledge that they pled guilty? So accountability for their actions that are clear, I think, can solve that problem where remorse doesn't quite fit. So.
Yeah, it's almost accountability plus insight. Remorse is sort of a more normative, like squishy, as long as we're using that word, rather accountability and insight. I kind of agree about the distinction between those words.
Anybody else who wants to add something at this point in time?
Let me just say that I think you still end up with a conundrum, though. If you use remorse along with accountability, you still end up in a situation where someone may say that they just didn't do it. And for that reason, I like the idea about the narrative. I think that may help a lot. It would be tough to put it into the matrices and somehow come up with something objective that would work. But if we can talk about the concept of being able to understand that there are situations, especially as Debbie pointed out, in the more serious crimes where someone was convicted of a crime by way of circumstantial evidence, and someone's saying, I understand that there was circumstantial evidence that indicated I was guilty, but I didn't do it. So in a narrative, we could say that there are times when you may take such positions into consideration, and you don't have to turn down the applicant because they failed to say that they did it and they feel remorseful. I agree with Larry that acting often can handle that situation, but there are those people who, for ethical reasons, may not want to act. So,
right.
Again, I like the idea of the narrative.
Yeah, and I also think about, Larry, what you mentioned, people are nervous at informal conferences, and different people react physiologically different to nerves, and sometimes that makes them seem more credible, and sometimes it makes them seem less, so.
I wonder if, say this half in jest, if we did a survey, what percentage of people who cry during moral character conferences get a pass versus people who don't?
Well, you could think of all sorts of criteria, right, that one could look at outcomes for sure, and that's one of them. But somebody who makes it to an informal conference, that is, they've had alleged misconduct that's egregious enough that it's sort of gone up the chain and gotten that far. The whole thing is predicated on the fact that the misconduct happened. If they have one act of alleged misconduct and they deny that it happened, that is a factual question that has to be addressed at the outset. Not only can you not be remorseful for something you didn't do, why would you engage in any rehabilitation at all, affirmative rehabilitation?
Because you have to, if you want to become a lawyer. Like, you're going to do things even if, you don't feel it's part. I mean, I know plenty of people who've been to prison. Plenty of people have been to prison for serious crimes who think that they, who allege they didn't do it. But, in order to go to the parole board, they have to say that they did it, and they go through, and then they come out and they want to go to, get whatever license, and they know they have to go through, they know what the agency is looking for, and they're going to do what the agency is requiring of them.
Right.
So,
and that's a related but sort of distinct issue, right? Because in the first case, is somebody didn't do something and they're saying they didn't do it. And in the example you're saying they didn't do it, but they're saying they did it. And that's a good point. I mean, there should be ways that we should guard against that. Ultimately, if somebody's gonna say that they did something, you know, we're probably not going to go behind it too many times and try to determine whether they are simply saying they did. But again, I guess that's the point is we always have to be aware
I
of
think
looking
it's
at
then giving what
evidence.
Myron's suggesting is like making sure that people are aware that just because they don't admit that they did something, that doesn't mean that they're not going to be able to overcome. I
Yeah,
mean, word on the street is that you're looking for accountability and remorse and insight, and people know, applicants know, that's, at least the applicants I talk to are the ones who have criminal record, because they somehow come to me. That you need to be able to, you know, that you have to be remorseful, you have to be, you know, you have to show accountability, you know, have to have the insight of what you've done wrong. So they know that that's what you're looking, they know that that's emphasized. Even if it's interesting to me that it's not in the statement,
yeah,
because that's, you know, of the three things that they think that are most important are candor, accountability, and I'm forgetting the last one, but like,
yeah. I
it's
mean,
interesting to me that it's not actually in the moral character statement. And yet that's what they believe is the most important. And when I've talked to former state bar officials and CBE members, they say that's what they were looking for.
hopefully they're also know that we're looking for truthfulness. But I get your point clearly. You know, sometimes people go through the motions because
That's how they
they
ended
think
up.
that's what they have to do. So yeah, something to think about and maybe include in some sort of more narrative document.
At least initially my thoughts, so ideally we would like to finalize the matrices, have them finalized for the January meeting, and then we were going to go and revisit the statement and guidelines, so that way the working group can look and see at the proposed language, see if it's necessary for each topic, but between now and then, if the working group would like, staff can try to expand on this. I don't think we're gonna be able to have a separate exposition piece, but in the context of the statement and guidelines that we're already looking at, we can expand upon this topic and present that at the next meeting.
Yeah, I think that sounds like a good idea. That you know, it's not a total separate thing from the statement and guidelines, but that is exactly, I think that's what the working group members are talking about.
Sorry, I have a quick follow-up question for Debbie. You talked about one of the efforts that the parole board makes, or those coming to the parole board, is this meeting with the forensic psychologist. I'm curious about what the objective is and what happens at that session.
It's in part, it's a little different than what you'd be looking for, but in part they're looking to assess risk of reoffending.
Mhm.
So there's a whole interview that's undertaken so that they can determine that the person's risk of reoffending isn't too high. But there's other things that end up getting discussed. And there's a whole forensic psychology unit. They use a particular test. And that's information that's shared with the parole board to determine, like, is the person low, medium, high risk of reoffending, those kinds of things. Yeah.
Thank you.
It's probably not there's a lot of controversy about that unit as well, and about the tests that they use and whether or not it's actually validated for the California lifer population that it's being used for. So, you know, that's a whole other set of questions.
So along the same line, if you have a basic rule that says the applicant has the initial burden of proof of good moral character, and if the applicant comes in and they have pled guilty or been found guilty of a crime, then it seems to me that burden still rests on them. So if they didn't commit the crime, or they say, I didn't do anything wrong, the burden is still on them to prove that. It's not on us to prove that's not to be the case. So I think that has to be factored in somehow. It's not our job to prove they are taking accountability. It's their job to prove accountability, I think.
I think that's right. Yeah, I think a harder case would be one in which there wasn't a conviction, or, you know, another fact finder hadn't already sifted through the evidence, at least purportedly. But yeah, that's important to keep in mind. I mean, the burden is on them, the initial burden.
But if you've got a case in which they've been accused of a crime that there has never been found guilty, you know, and there isn't proof, at least our counsel says we don't believe there's proof that we can prove that crime existed, I don't think we can consider it.
Right, I don't think
And
we,
the burden doesn't shift.
they probably wouldn't have never made it to, hopefully, to a informal conference, right? If that was their only thing and there wasn't sufficient evidence to show that it actually happened. And remember, as a general matter, if there are equal, you know, inferences from evidence, the applicant gets the benefit there. And that's worth keeping in mind too, although not as much so when it was particularly serious misconduct, I guess.
I'd like to comment on your proposed language back a couple of slides.
Sure. About remorse or
I
rehabilitation?
think the one before this.
Okay, yeah, here it is.
The last line, the last couple lines are in the last sentence. The relevant legal education courses,
Yep.
while important, they don't have the same degree of overarching life change that all the earlier examples. And I wonder if that last clause doesn't somewhat diminish the import of the gravity of the earlier examples. I don't know whether that should be set off, because it's pretty easy to take legal education courses.
No, that's true. I get your point. It's not quite as lofty a concept.
Yeah, that's the idea.
Point taken.
I mean, you could put in something like restorative
Restorative justice.
some kind of restorative justice, right, like action, so that would be like maybe completing drug treatment if your offense was drug related, or if it's some kind of amends that you make to an individual victim, or to anger management classes that you've maybe taken, you know, something like that, that's more actually connected to the misconduct.
I think that's a good point. Maybe it could be a loftier concept that captures more than just MCLE. You know, you're right, anger management, things of that nature. So we can think about, you know, how that should be drafted.
And that could possibly be just a second sentence, but you know, put a period after the performing community service, and then a new sentence saying that as part of the rehabilitation, a course of education that's consistent with the rehabilitation is also expected. That at least keeps it from reducing the loftiness of the prior clauses.
Yeah. Great, I'll make a note.
Unless we have other comments on this point, I'm going to move to 2D, review and discussion of moral character decisional matrix. Juliani is the person in charge of this. Do we have all the matrices?
Yes, so Ezra should have given you a copy, hopefully with your materials. If you need one, just let him know. He'll pass it out right now. But so he went through and any updates that were made, he just combines them. Obviously, this is not a finalized product, but for now, I'm just trying to have it in somewhat of a similar format. So maybe if we want to start with the groups and any changes since last meeting or any updates that have been made, that would.
And let's just say up front here, that clearly it should say seldom relevant.
Oh, okay, yeah.
Yeah.
On the first page there. Yeah, sorry. Yeah, that'll be corrected, sorry.
So is that for all three? Yes.
Mhm.
All three.
Yeah, we'll change all those.
Yeah.
What is that changing?
Oh, so in the second box on the first row, and then some of the subsequent ones, it says seldom irrelevant. And should say, it meaning, a municipal violation, it's talking about indecent exposure, excessive garbage, overgrown weeds, that would be, it should mean seldom relevant. That is of a low enough sort of concern that it's usually not relevant to a moral character determination.
So just get rid of the IR and the six boxes.
Yeah, it's only 2 letters, but it makes a big difference.
So David, we also have a few in there that still say irrelevant, where they should all be probably seldom relevant. So
Okay.
those are just kind of typo kind of things.
Okay,
Neither of us really looked at this until today, so I apologize, but, so we can do that offline, we don't need to do that in every box unless you want to do that.
well, we'll certainly go through and copy edit, and, I'm glad people are flagging these particular things. The groups, as they work on their own, they can also make changes and corrections, but, we'll try to do a decent copy edit.
Because we had agreed at the last meeting that we wanted the irrelevant to read seldom relevant.
That's right.
Anywhere that it says irrelevant, it should probably be changed to read seldom relevant.
Agreed, and yeah, thank you.
Sure.
Would that apply under vehicle codes, the informal comments may be needed? I'm curious why it says seldom irrelevant or seldom relevant there when you've got hit and run needing additional inquiry. You're just saying seldom is a vehicle code violation ever going to require an informal conference? Is that what you're kind of saying?
Are you talking, so if it's older than 5 years is when it would have been seldom relevant, right? Is that what you're talking about?
I guess under vehicle code misdemeanors, hit and run, reckless driving, failure to appear, is it kind of your position that those sort of things would seldom require an informal conference?
If it's 5 years or older, correct?
Or any time?
5 years.
Yeah, driving without a license.
So the question is, the word seldom relevant, and it's incorrectly says seldom irrelevant in the informal conference may be needed column. What is meant by that? Because the additional inquiry necessary to the
Yeah,
left
there
of that.
shouldn't be anything in that column.
Okay, got it.
It should be blank.
Yeah, it should be blank.
It should be blank.
Got it.
Hit and run, we would want an additional inquiry, and reckless driving, if it's 5 years, within the last 5 years, we might want an additional inquiry. We have to focus in a little more, which I can live with.
Yeah.
We can.
Hit and run is only a misdemeanor.
On the next page, juvenile misdemeanors and felonies.
There is a wobbler. It could be both. Hit and run can be a misdemeanor or it can be a felony. It can be both.
So, and again, on juvenile misdemeanors and juvenile felonies, did you have any comments or thoughts on the aggravating or mitigating factors? In the past, we've kind of looked at people's family situation and considering mitigating factors.
I thought we had given a whole list of aggravating and mitigating factors that we thought were relevant to all the categories. So that related to convictions.
It's only in the last box, but it goes to everything.
That's right. We talked about how it might be sort of redundant to just put the same long list in each.
They're relevant.
And so we'll have to, in the final product, somehow indicate, maybe they'll be in the first one and then the other ones will say see above or something. Since they'll essentially be the same ones that are relevant to all categories.
It's on the very last page.
I mean, when there are topic-specific mitigating and aggravating factors, I suppose they should be there.
I think those were the ones we gave.
And no, you're right.
The list that we gave is not currently on the chart, so I can re-email it to you. But we gave both things that we thought were evidence of rehabilitation and then mitigating factors, which we consider different.
They're down here.
Yeah, they're different from one another. Like evidence of rehabilitation is something that you do after the offense takes place versus mitigating factors are things that occur like, how old were you when the offense took place? As opposed to, did you do drug treatment after you were convicted? So we have that list, I can re-email it to you, but that belongs with everything. It came in the matrix, we had it after
At the bottom.
Okay.
I think it
it
just,
wasn't in
I think
the
it just got
actual
lost in
boxes.
the transition from
Yeah,
one
you
format
didn't
to
put
the
it
other,
right,
so.
so if you look at the paragraph, it's like at the very end, it didn't make it into the boxes because it was too much and it applied to everything, so we just kind of said, in the whole long laundry list.
Sorry, I should have saved the figure after getting it into the boxes.
For the substance of it though, were there any changes that you had to your matrix between this meeting and the last one?
Guilty as charged, we did not have charged.
Okay,
We've both
that's
been,
fine.
I
Wait, no, it was a quicker
finished two
turnaround than I
documents
was had.
in the last
Okay,
few weeks, so yeah, we haven't had a chance to,
okay, not a problem.
I'm taking accountability for
Me too.
the offense for that.
And I'm very remorseful.
Yeah, I have a lot of insight about
I
it.
can't cry, I'm sorry.
Going back to what Dean Stevens was talking about earlier about having kind of some notes outside the matrix, one thing that I find confusing, because I don't do criminal law, this whole idea of expunged versus cleansed or paroled, or what those different things are and how they fit into the process. So
Do you want a
maybe someone
definition?
who understands those things and kind of explain them so that whoever looks at this can say, oh, I see I fall within that category, maybe helps. I'm not sure, but it certainly would help, I think.
So
Aren't there?
we could include that, it's the penal code section 1203.4 really does, it lays it out, but we could put it into the matrix so that people don't have to go digging through a penal code section. But it's pretty clear when you qualify for an expungement, when you don't. But basically, as long as you successfully complete your probation, and it's a misdemeanor or a non-violent felony that can be reduced to a misdemeanor, the law presumes, gives you the ability to have your case expunged. And the expungement would be valid for purposes of having to self-report whether or not you were committed of the crime. But then there are exceptions, and applying for licenses are exceptions also. So even though it's expunged, it still may be reportable during certain periods of time. And then if you read the case law that goes along with misdemeanors, in particular, the presumption is that people are to be, if they successfully complete, presumed to be rehabilitated. So as long as you do everything that was required of you during your probation, you are presumptively entitled to an expungement.
And can I just add, Jim, I know from being in informal conferences also and looking at statutes that people submit from various jurisdictions with their moral character application, that the word expungement, people use it sometimes colloquially to mean certain things, and different jurisdictions use it in different ways. Is it an expungement if the records aren't literally destroyed but are preserved because they can be used under certain exceptions, like in a future prosecution? Some jurisdictions call that a dismissal, some call it an expungement. So there can be some, those words get a little confusing to me sometimes.
And in California, we have something called purging, which is a little bit different too. And then other jurisdictions have expungement and sealing.
Yeah, exactly. It's
So,
all
and
of
if
these
they're coming
terms.
from a different jurisdiction, they might have had their records sealed, which gets more complicated.
So in California, I think we were talking about this, did pass a law in January of 2019 regarding sealing of records and what constitutes the ability to have your records sealed, which is very different than an expungement. An expungement, you're not entitled to records to be sealed. That conviction will remain on your criminal history, just it reflects that it was expunged. The sealing entitles you to actually have it removed from your criminal history. But you cannot have been convicted, it must have been dismissed in the interest of justice, or you were found not guilty. And there's a laundry list. So we can include these laundry list kind of things to make it easier for people when if somebody tries to fall within one of these categories. But expungement, you're right, there are other interpretations for the word.
But Tara, can you send us this? So that when we're doing any editing, we're doing it off of the Word document now? The update, the one as of today?
I'll have that sent out after the meeting.
Okay, thank you.
I think if nothing else on those, then we can go to the next group, which, Larry, I don't believe you and Meredith had any changes from the last time, but I don't know if you want to talk a little bit about the technical denials that we sent some information on.
This is the honesty.
Valerian, can you hear me?
Yes.
Go ahead, Meredith.
Stage is that?
Okay. Larry and I did not meet further to discuss this, but we did get some information from Tara that was helpful. So, Larry, do you want to fill them in?
I can't remember.
Essentially,
Yeah, I don't remember what it was, actually. I'm sorry.
well, for one of our categories, we had thought perhaps no further inquiry would be necessary if licensure in another area had been denied on a technicality.
Oh, right.
And it looks like that's just not something that really happened.
Right.
So I don't think that's necessarily included in the matrix.
Right.
More robust.
Showing a little bit of my ignorance here. I don't know how you would define this between a conduct code school violation and an honor code school violation. Are they distinctly different? And how do they differ?
With, at least at my institution, they are distinctly different. I know many institutions have separate codes of conduct that are distinct from their honor code. Some schools have a code of conduct that does include the academic integrity principles, but a lot of schools do segment them out. But in essence, we treated them really sort of the same, which was based on the level of violation.
So how do we know, the state bar know, whether it's an honor code or conduct code violation?
So we get the information from the applicant and then the law school itself, and it'll typically state on there exactly what it was, what code they violated, so.
And if it's the case that different schools might use different terms, clearly it's the underlying conduct that's the focus. Although I don't know, perhaps schools are consistent in the way they use honor code, code of conduct.
I would guess that they're not consistent. I can tell you that with our school, we call it the honor code, but it includes conduct violations and can include some academic violations, so it's a bit of a mix. So I think it's good to not go by the name of the code and just try to figure out what it's about.
Yep, look at the conduct, sure.
No, I'm from UC Berkeley and Press. Academic cheating is an honor code violation.
Let me find, get you a mic, hold on a second.
Let's see, do I need a mic? Oh, sorry.
Okay, and then officially, I'm going to reopen public comment to ask you to identify yourself and comment.
Oh, okay, sorry. I'm Carol Rockwell. I'm the registrar at the UC Berkeley School of Law. This is Claire Blyde, who's our associate registrar. And no, we're really interested in what you guys are doing here with the matrix because we've been seeing really disparate outcomes lately with our students, including for cheating in law school. We've had students that have just kind of flown through after they've been cheating, and students that have been stopped. And we're not really sure how to advise them anymore. In the past, it seemed like it was more there was severity of conduct and recency of it. So we had, for example, somebody who had committed a crime, as a juvenile and had had something happen in law school. Now it seems like there's an or. It's severe or it's recent. So we had somebody who had nothing other than cheating in law school, like I said, get hung up in moral character when other people were fine. And then we had somebody else who had DUIs a long time ago and nothing else that we're aware of, and got hung up. So now we're worried, like when do we tell students that they're going to have problems? When should they get a lawyer? Which is very expensive for a lot of them. And so it just, is this a consistency amongst the analysts? It just, like I was saying, we're just seeing very different outcomes.
Well, I'm going to kind of respond slightly. Part of the idea here is to come up with clear guidelines so both students, schools, and bar kind of have some rules to work from. But I'm going to segue that into this idea. I would consider cheating in law school would be an honor code violation. Essentially, you violated some rule the teacher or the school has set forth. And because this is where we are, Larry, is under law school page 7, violation. You've got infraction, serious violation, but maybe you can give me some examples of what would be an infraction or a serious violation. Is plagiarism a serious violation or infraction? Is turning in a paper late? Lying about being sick? I don't. How does the student know where he would fit in here, or she would fit in here? So let's maybe look to some of the schools and say, what would you consider to be an infraction as compared to a serious violation? Are you there, Meredith?
I'm here. So, I think I referenced this last time. The way our honor code is written, it is possible for a student to violate it without actually having intent. For example, they accidentally bring materials into a closed book exam. So that would most likely, if there was perceived lack of intent, that would be an infraction because they did violate and potentially benefit from the violation. But a serious violation would be something like plagiarism or collusion on an exam followed by trying to conceal that collusion. So there certainly are different levels, but it depends. It's very situationally dependent, and I think what we had discussed last time was relying on the expertise of the staff who are conducting these to see what comes up with the most frequency in terms of helping us categorize those things.
Well, at a practical level, let's just take a student who plagiarizes exam, which I understand is easier than it used to be, because of some computer programs, which I don't understand either. But somehow you can have someone else's paper, and you can turn it in, and I guess there also are programs that you can test to see if this has been plagiarized, and if a student gets caught. What does the committee do with that? What should we say in that situation? We believe that person should be denied moral character for a year, or should be required to do something? How do we give guidance to the state bar if that's in fact why we're here?
That language in the 4th column about serious violation is defined by the school. I think that there's a lot of wisdom in that because schools do vary widely on what they have in their honor code violations, and the culture of the schools can treat offenses quite differently. And they make their decisions without consulting other schools and doing so. There's less consistency among schools than you might hope that there is. And the division between honor code violation and code of conduct is equally as diverse. Like And schools that don't require, or don't allow smoking on campus, that would be considered a violation of some kind. Hardly the kind of gravity that you think with an honor code violation generally. But there are some schools that don't have a separate code of conduct from an honor code. So that would technically fit under an honor code violation, even though nobody would take it nearly as seriously as plagiarism or cheating offense.
So it sounds like that may cut the other way, right? A school might define a violation as serious when, by and large, schools don't define the same violation as serious, smoking on campus or something. That might cut toward looking at the underlying conduct, I suppose, rather than. Oh, go ahead, Meredith.
I think that's really what we were trying to get at, was looking both at what the school, how the school defines it, but also looking at what the staff themselves are seeing and trying to come up with some consistency there. Because it is about the underlying conduct. So yes, my school has a separate honor code and a separate code of conduct, but it's about the behavior. And if someone is, sufficiently severe or pervasively violating either one of those things, say it even is smoking. What if you're every single day smoking on campus, and every single day, you're flouting that policy and you're getting in trouble every single day? Is that as egregious as plagiarizing a law school exam? No, but it is showing a disregard for, rules. So I think it is about the conduct and less about the individual institution's definition, which is why we raised that as a question when we were including that as a possibility on the matrix.
That makes sense. And, the aggravating and mitigating factors address some of this, because that's when you dig down into the actual facts of the case, I suppose.
So perhaps what we can do is try to develop some common examples with the help of the staff, like what do you see most frequently, and we could put examples in, like plagiarism would probably always go into the category of requiring additional inquiry, but a low-level code of conduct violation might not.
Yeah, and frankly, as things stand now, if somebody has a documented case of having cheated in law school, they should not be flying through the moral character process without any scrutiny. That's something that, in practice, that's a big flag, and that's something we would look at. I can't speak to individual cases, of course, but.
But what does the student do? The students screwed up, and whether they were too busy or somebody said, hey, this is okay or whatever. They're there, and they're in their second year of law school, and they paid a whole lot of money to get this far, and to tell them basically you're not going to get your license for 3 years, I don't think that's the answer. And they're remorseful. They got caught, and they're probably never going to cheat again. And take responsibility, because they got caught. But what are we going to tell them what do we want to see from them to show that they really understand? And I don't have answers. I'm kind of looking to you folks so we can put something in here so that students can say, yes, there is light at the end of the tunnel. You can still get your license even though you plagiarized. You may have to pay some dues. You may have to do something. And I don't want to say these are the 3 things you have to do, but it would be nice to give some examples. Does anybody have any thoughts on that area? These are your students, not yours specifically.
Some examples of things that we've seen students do after having been caught cheating is apologize to the professor. Maybe
Some of them that go and talk to like the 1L class during orientations, or write a piece and publish it in the school newspaper, things of that nature.
Yeah, talking about their experience. And, those are some examples. I don't know if the deans have thoughts about that.
absolute bare minimum would be complying with the sanctions imposed by the law school itself or the institution itself. That would be a minimum starting point. Because if something is imposed, maybe one of those things you just described was imposed as a sanction and they did it, then they're just doing it because they have to. So bare minimum would be completing any sanctions if imposed, and then whatever they do on top of that. For example, the ideas that you just suggested, any kind of outreach to their community, any kind of demonstrated remorse to the faculty member. I think those would be certainly positive. I don't know how often that happens outside of the assigned sanctions, but I'm sure students would do it more if they knew that it would be helpful.
Yeah, and your point is well taken. Just like, the Supreme Court doesn't give as much probative weight to evidence of rehabilitation when it's something that was court ordered in a criminal case. I agree, that you have to comply with whatever the sanction was.
It seems like the context of the school has to be taken into account to some extent, because the manner in which the schools deal with the issue is so different from one school to another. When we were developing our policy, we did look at a few other schools, and we went in a pretty unique direction, just because it seemed to fit the context of our students well. We had a mandatory dismissal from the school for plagiarism, so presumably nobody would ever get to this point because they never graduate if they plagiarized. But we also had a very compassionate application of it to first-year students, because we do have students coming in that appear very committed to doing the right thing, but they very sincerely do not understand the concept of plagiarism until they've actually committed it. So we did not expel students for a first-year violation if there was a means of seeing that we could work through them. And strangely, for some of them, we did require a paper afterwards, and they plagiarized that paper before turning it in. So it clearly wasn't sinking in. But I think what we did there worked really well for our school, but it's based upon looking at the pool of our students. And I think most schools do a very similar thing. I think you find the standards very, very different. But some schools are really highly tolerant of plagiarism by having a relatively minor penalty. And some schools don't do a very good job of investigating to see if there is plagiarism. A lot of that depends on what the administration's demands of faculty are in their investigation. Certainly it's easier to give a pass to plagiarism when you suspect it than it is to look into it deeply. But there are other schools that take a very aggressive stance. So I don't think we can assume a great deal of uniformity in the way schools handle plagiarism or cheating.
And we don't want to encourage schools to not call people on plagiarism because it's going to prevent people from passing the bar or becoming lawyers. That's counterproductive. You've got to find solutions out there somewhere.
We've had it come up a number of times at our school, and what happens is there's some action taken after a hearing. The action ranges between a reprimand and a dismissal. Seems like often it's dismissal. But in answer to your question, Jim, that you asked a little while ago, what do we do in the way of suggesting a way to rehabilitate these people? We don't get involved in that, really. And I don't know what to suggest. It's not like there's something equivalent to an anger management course or Alcoholics Anonymous that we can send somebody to for purposes of correcting this sort of conduct. It would be nice if there was, that's for sure. So yeah, we've not given suggestions to people as to how they can go about doing what's needed to change their character so that they don't cheat in that way. But I suppose we should think about it a little bit. Maybe there is something that can be suggested.
And, it's worth remembering, too, that the court has held that, the court has noted that when somebody commits, an honor code violation, cheating in law school, the court considers it particularly egregious, more so than undergrad, because it feels that they should have a heightened knowledge of, the honesty and whatnot that a lawyer should possess. So that it's something that the court takes very seriously.
But it's not a bar, and the court said it's not a bar.
Correct.
It's something that has to be overcome.
Sometimes I think going through the moral character process and actually going to an informal conference in itself has the ability to impart the seriousness of the situation on some of these folks.
Absolutely.
Looking at,
But I do think that some of the schools are looking for guidance in terms of what to tell students, and I think that how the state bar learns about the cheating incident itself is very important. Is it something that students should report, or do we wait and find out later? And it speaks to candor as well. So I think that one of the mitigating factors in how we see cheating incidents or how we treat them is also how we learn about them too. Because we do have students that decide not to dispel, and then we find out at a later point. And I think that becomes a bigger issue than it probably should have been initially. So I just want to put that out there too, that it's not just the fact that somebody was cheating, it's also how this person has either demonstrated accountability, and part of that is the reporting process. Just want to put that out there.
but if it's like the first year or second year, and they've got a year and a half to rehabilitate or to get themselves back on track, if they know they've got to do something and get working on it sooner, then they're likely to still be able to keep the same path, rather than do nothing about it until they graduated, passed the bar exam, and then suddenly these people who they've never met before tell them you can't have your license for another year or two. It doesn't seem fair. It does seem fair that they can't get their license, but there ought to be some way to avoid that. And I'd like to see if we can find some way to put that in there somewhere.
And you just touched on something that when lawyers do a threshold level of that requires a sanction, they get reported to the state bar. Maybe we could come up with something like that, a similar kind of threshold conduct that would have the student have to be reported to the state bar. And there's a monitoring system, and maybe that informal conference happens much sooner. So just the fact of going through a hearing would have some kind of impact. I don't know what that threshold is, but I think that's a really good idea. I mean, if students have to self-report, or the schools have to report that we had, a cheating situation that, again, whatever the threshold is, it's over $1,000, sanctioned over $1,000 as an attorney, you're required to self-report to the state bar, and if it's certain kinds of misconduct, then bench officers are required to do it. Maybe there's something we can do similarly for students. Then they don't have to wait till the very end to figure out what they need to do to work towards getting their license.
I think that's a great idea. It sounds labor intensive on the bar's end. Is that feasible? Because if it is, I think it's a great idea.
Well, there's the committee between the state bar and the schools, at least the Cal schools. They can start talking about how are we going to deal with this early on.
That question comes up all the time, is that a student commits an offense, and everybody, administration and students have a conversation of, this may have an impact on you when you do your moral character thing, but then the conversation ends with nobody having any idea what's going to happen next. It'd be wonderful to know if there was a drop-dead issue that's going to have a huge impact on whether the student should even finish their program. It'd be really quite a good thing if that could be addressed early on.
One of the things we had talked about was the last meeting or 2 meetings ago was having this potential proposed best practices for the schools, so we could add in, because we do ask the schools for information in the law school declaration on some of them. If something happens between the time that they've submitted it to us and the moral character being done, they'll let us know, but not always. So that's one thing we could add in, is having the school report it itself, as well as if there is some type of honor code violation or plagiarism, we can make suggestions as to what they could tell the students, something of that nature.
Something like the lawyer's ethics.
Right, so
Hotline.
ethics school, yeah, something.
But I mean, you've got an
like-
ethics hotline, you say, I've got an issue and I don't know what to do with it. Is it possible for the school to say, I have this student who I'm not gonna identify but has these problems? Can you make some suggestions about how the student might address those issues? Is that even possible?
Yeah,
I'm not even on committee right now.
I mean,
That would be helpful if you've got a second-year student who has a plagiarism issue, and you're not going to kick him out of school or her out of school for some reason, but you're going to say, this is going to give you a problem in moral character. Let's address this issue now. Let's go to the state bar. Let's maybe get some thoughts, some inputs, or I'll go and see if I can find out what to do. It might be helpful. Then, when they're in the third year of school, they can know, if I do these extra things, I've got a better chance of passing.
Isn't that presumably like what we have though for the criminal records stuff? It's the list of evidence of rehabilitation that you're looking for. So isn't it constructing some kind of list like for that, for these kinds of violations?
It could be too, but I'm not sure what that list would be for plagiarism. I mean, you can say, if you got convicted of drunk driving, if you go talk to, or drinking underage, you go talk to other kids at school and say, don't drink underage, you get in trouble, this is what happens, this is what happened to me, don't do it. You know, is that what you do with plagiarism too? It's kind of a tough thing for a second-year law student to go to first-year law students and say, hey, I screw up, I plagiarized, don't you do it? But it certainly might be useful.
No, we're holding people with criminal records to a pretty high standard. Why can't we be holding law students who are plagiarizing while they're in law school to a high standard?
But it comes up in other issues as well. We had a student who seemed to be a student of fine moral character. We really wanted him to succeed. He was heavily involved in the school in a very positive way, and we thought his character was high. And he was a stockbroker prior to going to law school and had his FINRA license pulled a couple years before he went. And it always felt like it was a crapshoot while going through law school. He was taking on $120,000 worth of debt. And there was always this issue, what's going to happen when the moral character evaluation comes up? And it just seemed wrong that there had to be all this investment of money before there was a determination on that issue. If there was any way around that kind of thing, these are rare circumstances, but they're very specific, noble ones.
New York does that. They have a preliminary moral character that the state bar, like you can go in front of the state bar before you apply to law school, before you matriculate to law school to figure out basically whether or not something in your record would preclude you from being able to pass the moral character component of the state bar requirement.
That could really be useful, just given the cost of legal education. That's useful.
It is. I've talked about it with the state bar here, and the answer is that the level of resources it requires is pretty difficult because they do a lot of extensive research and investigation of current applicants, and to do that for presumed applicants, they would end up doing what they said is a pretty cursory review, and then would probably end up err on the side of giving people conservative advice.
Well, and there are a couple.
That's just what I heard from former state bar officials.
That sounds about what I would expect, but it's not a cheap.
But there is a jurisdiction that does it. New York does do that.
I think it would require a rule change, and then it's also worth keeping in mind that, depending on when the misconduct occurred, the 3 years that one is in law school are 3 years of rehabilitation, presumably, if they don't commit further misconduct. So even if you could get a preliminary determination, it wouldn't be dispositive with respect to what a determination might be upon graduation. I still understand how it would be useful. But.
Well, and the case in point, everything turned out fine. Our assumption was he was going to make it. And his review was much longer than is typical, but he did get to get through it. So from that standpoint, the system worked exactly as good as it was supposed to. But it doesn't change that fact that there's this feeling up front that going to law school is a bit of a roll of the dice if you've got something in your background that was clearly considered a substantial violation, but you've got the same time and gravity issue that you've got people who have no experience in knowing how to assess the matter, trying to do an assessment and hoping they get it right.
Exactly, and that exactly highlights one of the purposes of this working group, hopefully, is to provide some predictive value so that somebody can at least look at these matrices and the standards and guidelines and say, okay, I wasn't convicted, my license was pulled, but there was no criminal conviction. I'm probably going to be okay if I conduct myself, well during law school, something like that. But yeah, I mean, as much of what this group produces that can provide predictive value to potential students, that's one of the things we're after.
David and Jim, I'm just wondering if like Meredith and maybe a few other law school deans could be able to come up with a list of, what you would be looking for in terms of evidence of rehabilitation or what people can do once something's happened. I mean, I imagine there's a number of examples of things that they would be looking for. So just getting at wanting to be as transparent as possible.
Okay.
So maybe moving beyond our committee, like, I don't know if that's kosher, but are we allowed to go to other people for examples or to get advice?
Well, a couple of things. It sounds like there is the thought that perhaps in the spirit of both, I think, like transparency and feedback, the idea of this preliminary review as well, it could get on that list of recommendations. And just in terms of process, recommendations from this working group are going to go to the Committee of Bar Examiners, eventually to the board, to adopt, the matrices, the entire process. So a recommendation for preliminary review could be added to that list, even though we know that it would take a different set of resources, that conditions change if somebody got a preliminary approval or whatever the case might be, or green light. But the point is that we're seeking ways of improving the process, and maybe it's something that we can't do now, but at least it's been documented that this would improve the process for law students altogether and for schools, right? In terms of feedback, though, it sounds like, Debbie, you're suggesting that if we came up with a list of potential sanctions or remedies to some of these school violations, whether it's honor code or school policy violations, that we could also bring in, we have another committee that Jim's alluded to, and this is the CS bars. We have CS bars, and we also have our law school council. CS bars comprised of deans from registered law schools and California accredited law schools. And our law school council is comprised of deans from ABA law schools. We could bring this material to both of those groups for feedback, so we have more input from, cast a wider net of deans. And so that is something that we could do. I mean, part of it, we'd have to time it, but there isn't anything that should prohibit us from gathering more feedback if that's going to strengthen these recommendations.
Or can staff members on their own, or committee members on their own, not meet with each other, but talk to third parties and gather information, bring it in? So, yeah, if you've got other people you want to talk to, I think under Beg and Clean, you and Meredith probably can't together talk with somebody else.
Yeah.
But you alone could, and then bring back, or Meredith alone could bring them back. So I think if we're in groups, then we're violating our open policy.
But staff could shuttle that information.
So, yes, the more information, the more we can solve these problems, I think the better we serve our students, our applicants. So, lunch is available. Do we want to go for a few more minutes, or do we want to break for lunch?
Did we finish that section?
We haven't finished this group yet. We've got a few more we can do if anybody else has any more they want to say. Page 11 is where Michael's and my group starts. So we've got fraud, admissions denials. Does anyone have anything they want to raise on pages 8, 9, and 10? Larry, this is still your group, isn't it? And Meredith?
The only thing I might
Just to point out, just as an FYI, is now under the whole bankruptcy past due debt, one of the mitigating factors we talked about, because it's in the news so much, of past due debt for medical care. And bankruptcy doesn't mention that specifically, but you know, you just hear so much about people with, have financial problems due to medical debt. And, the need to be much more flexible in that area than in other areas. So, just to flag that.
Yeah, I think so far we've kind of dealt with debt is the attempt to deal with the issue, even if if the attempt means I don't have the ability to pay it now, you simply aren't just ignoring it and throwing all your bills in the trash. You are acknowledging your obligation and saying, I'm planning on getting to it. A lot of students say, when I get a job, I'm going to make lots of money as a lawyer and then I can pay all my bills. And I hate to disillusion them that they're not going to make lots of money when they're a lawyer, but at least they have a plan.
Yeah, and Larry, I think your point highlights the fact that it's always worth keeping in mind what we're doing is assessing, whether people have the requisite moral character. And so the facts of individual cases are important. And your point is well taken with the medical debt example. Perhaps under certain circumstances in that case, it, would not be viewed by the State Bar or the committee as something that necessarily reflects poorly on someone's moral character.
So my suggestion is then that we break for lunch, half an hour, is that what we do? And then we'll get to Michael's and my group, civil actions and such, after lunch. Okay, so we're back on camera, we'll say that. Everyone's still here, we don't take what we're doing. I think where we are is now in the third section of the decisional matrix, and it's on page 11. What Michael and I did is combine our two matrices from the last meeting to make it a little easier for everybody to read. I may have overdone a little bit, but we tried to cover as much different areas as we could. I don't think we made any changes to this.
We made a few. We changed some of the headings. In other words, it changed domestic to family law and so on. But in the way of substantive changes, it was mentioned at the last meeting that there should be some reference to violations of support orders, violations of restraining orders. So that was added in the fourth column, page 1. And instead of separating them out to support orders, restraining orders, it just says claims of violations of court orders or non-payment. And then Jim, I think you added favorable termination of the litigation, the mitigating section on that page. We did that, and I don't know if that was made as a result of comments made at the last meeting or otherwise. We made a few other changes. Should I go through those or not?
Yeah, go ahead and cover those.
On page 2, the question came up regarding frivolous administrative claims, and the question was by whom? So we added by a judge of an administrative court. Did the same thing, let's see, in mitigating, where it says meritorious nature of applicants' administrative claims as being mitigating. The question was according to whom, and it's according to official findings in the matter. A favorable termination of the administrative action, that was added as a mitigating factor. Quite sure we did not have that in last time. Next page, we added acceptance of responsibility under mitigating. Previously, we had mentioned that it was mitigating if someone voluntarily admitted misconduct before gaining any knowledge that someone suspected misconduct. But then we added overall acceptance of responsibility as being mitigating. On the next page, we added in the fourth column over, allegations of sexual assault. That was an issue that was brought up at the last meeting. We talked about matters involving moral turpitude or matters that resulted in expulsion, and it was mentioned that there should be some specific reference to sexual assault, so we added that in that column. And then again, under mitigating, on that page, we placed acceptance of responsibility as being a factor. Those are the only notations I have regarding changes that we made.
Yeah, I think initially we were there was being an honor code and conduct code, and we kind of separated those. We were only talking about conduct code. Also, are we redundant on unenforced, unsatisfied judgments? I thought Larry's group also did unsatisfied judgments. Past due deaths and collections. Can we combine those two maybe? I'm not sure why we would have them as two separate columns. These are on page 9, past due deaths and collection versus unsatisfied judgments.
Yeah, I suppose it is simply a type of unsatisfied, or the debt. Can I ask what your source was for your definition of moral turpitude?
That was a code, but I can't remember off the top of my head which one, so I can get back to you on that.
I'm just curious.
Does it comport with
I think
how you would do it?
I think so. You know, the court has said that the phrase moral turpitude has meaning that is specific to the context in which it's being discussed, which is to say that in the legal context, in the professional context, as you point out, it goes to things that are essential characteristics of an ethical attorney. So things that involve dishonesty or, taking money from clients, things of that nature. It generally emphasizes more, the base, vile, or depraved conduct that's shocking to a reasonable person. I think, I think it's probably true that moral turpitude, I can't imagine somebody saying that those things would not be included. They're a little less, they're a little bit question begging, but that's sort of the nature of moral turpitude, I suppose,
Well, that wording is word for word out of one of the codes, one of the California codes.
Don't want to spend too much time on this, but I want to make sure that we do. So is page 23 online kind of a redundant page 2? I think it may be. I'm sorry, which
I think so.
page 23?
Oh,
Yeah.
Oh, yeah.
Which line?
Page 23 looks like it's a redundant earlier items that just maybe got stuck in from before, the last page. There's all those things we covered in the earlier pages. Hold on. So with respect to the decisional matrix itself, does anybody have any particular comments or questions they want to make about that at this time? It's not a done product, but I think it's closer to being a done product. I like the idea of adding some notes at the bottom that says, cheating on plagiarism isn't of itself a bar to practicing law. Committing offenses is not a bar to practicing law. I don't know how we do that, but we can talk about that later. So, I should have said it earlier. Anybody else have anything else they want to cover with respect to 2B, the review and discussion of the decisional matrix at this time?
If we can go back to page 9, I think it's Larry and Meredith's group. For the past due debt and debt and collections, it says default on X type of loans. I know last time we had a little bit of a discussion about it, but I don't know if we want to bring that up again to kind of flesh that out a little bit now, or if you'd like to revisit that and bring it next time.
I'm sorry, which one, which item again?
The past due debt and collections, under additional inquiry necessary, it said default on X types of loans.
Yeah, we just generally wanted to discuss that with the working group. I think I don't necessarily believe that we need to differentiate between different types of loans, but I don't want to speak for you, Larry, but I think Larry might have had some questions about, is a mortgage better or worse than defaulting on a student loan, that sort of thing, or do we want to differentiate at all? That was just something we wanted to raise quickly with the group.
Right.
Or a debt owed to a luxury department store as compared to a debt owed to a hospital. Maybe there is a difference, maybe there isn't.
Right. Or somebody started a business and, borrowed $100,000 and it went, and maybe they didn't even borrow it from a bank, but they borrowed it from a venture capitalist or somebody like that. And it went belly up. Is that different from a department store?
So if we broke them into necessity of life type debt, I think the family code says your spouse is responsible for necessity of life expenses of your spouse, but not non-essential, essentials of life. But I think it does differentiate between those types of debts. Do we want to look at the difference, or do we care?
I think it's all the same.
Okay.
I'm sorry?
I think it's all the same. I mean, again, you're gonna be looking at totality of circumstances and how people got to where they're at. So I don't think we need to distinguish the types of debts. We have to look at how the person got to the place they are with the issue with the debt. So I don't think we need to distinguish the types of debt.
And I would agree with that, with the addition of adding medical debt as a possible mitigating circumstance.
Absolutely, and I think you already have that in your matrix, and I completely agree with that.
Okay,
Everybody agrees, we'll just make the change then.
so we're gonna just get rid of types of, just say that's. Okay, so if we need to come back on this, we can, but right now then I'm gonna move to business C, review and discussion of the application for determination of moral character. And I think that's, Tara, you're gonna start with this?
So everybody in their binder should have the actual application itself. If you need an additional copy, Ezra does have them. I think I'll get it to Meredith, and so then we also printed out for you a copy of the law school declaration. So this is something we've talked about a few times, where question 1B is inconsistent with what is currently asked on the application itself regarding the criminal conviction, so.
And also not phrased very well. I don't know what an informal violation is. And I asked the judge, she didn't know.
Yeah, we don't know what that is.
I don't know if we'd like to discuss it now and any suggested changes, or if you'd like to take it back and look at it, but there was a request at the last meeting to go ahead and review this and the application in light of having learned more about the process and the individual topics itself.
So we actually have the question asked of the applicants somewhere in our binder?
I believe you do have the entire
Yes, I do.
application, the
It's page 32
By the way.
in the application itself. I believe it's tab 7 in the binder.
That's number 7. Yeah, I feel pretty strongly that it should mirror what's asked of the applicants. I think it ends up setting up, it creates a lot of confusion for the law schools in terms of what they then ask the applicants on their applications. So a lot of them are asking about arrests even though the applicant is not asked about that when they apply for the state bar. But the only reason why they're doing that when you ask the law schools is because the declaration requires them to know that information. So it just feels a little bit like creating a little bit of a gotcha for applicants. It's not really necessary.
and
I just don't understand, I don't understand where you're at. I guess I'm gonna ask it back to you. Why would you want more information than when you're asking the applicant him or herself?
So we discussed this one. Actually, unfortunately, don't know where this originated from. I think it's just persisted, the language, and we don't know if it just hasn't changed with the application itself.
yeah, we're unsure of the legislative history, as it were.
Okay.
I will say, I mean, at the risk of over-parsing, when you say the schools ask because they know they're going to be required to know, I mean, technically, do the records in your office reflect that the applicant has been? And so presumably if the school doesn't ask, the information's not in its records.
No, but they look at, this is, at least what they told us, the admissions deans, that part of why they're asking is
Because they know.
because they know it's going to be asked of them.
Yeah, at Berkeley, we do find a lot of anxiety with students because they are, asked something different, from the bar versus what we ask them for.
If you're gonna talk, I'd like you to use the mic.
Sorry, I thought I had it on. So I just wanted to kind of echo what was being said, that, it does create this discrepancy when we're dealing with students and anxiety. It would be so much easier for us if the two questions mirrored each other.
So can we maybe have some proposed language for next meeting?
In light of what we've talked about with the matrices, is there anything else on the declaration that needed to be?
I just wanted to make a note that 1G will be taken off, and that's in light of the SB 544. It just, we just have to go in and have someone take it out with the coding itself, so.
Yeah, that's the question that asks if the applicant or the student has been diagnosed or treated for a chemical dependency that would currently interfere with his or her ability to practice law. And so under the new Business and Professions Code, Section 6060, as of January 1st, we will not be, and we're already leaning
making this change.
we're becoming compliant with that law early. We cannot and will not ask for medical records related to mental health.
So as a way of background, how does what you've just given us get in front of a student, or sorry, a school's personnel to fill out? Do they get an email that says, please fill this out as to these 80 people, or do they get one for each person, or how does that happen?
So it's an email, so when the applicant submits their application, they have to enter what their law school, the dates that they attended, and then upon submission of the application, an email is sent to them where they have to click on it, and then they fill out the questionnaire.
So email is sent to a particular person at the school.
It's sent to the email address the school's given us. Sometimes it's the registrar, other times they have a particular person. So we're working, because right now it's a field that's shared with the rest of admissions, so we're building a separate field for the moral character questionnaire itself, so.
Okay, so in California, we've got some 50-some schools that you send this to, and then nationwide, you have another 150 or 200 schools?
So we default to either the dean or the registrar, and then if the school tells us otherwise, then we update it to whatever that particular email address is.
And then you don't get it back, you send out another one?
Yeah, so the system will automatically kick it out, I think it's every 30 days for 3 times, and then if we still don't get a response, then it would go to an investigator, and the investigator would typically make calls, email someone specific at the school, rather than the general address.
So what are you gonna do about getting rid of G now, since it shouldn't be in there at all? Are you just telling them not to answer G, or are you gonna get it out before this next email goes out, or just curious?
So we're just gonna have IT take it out, so it's just a separate application that we don't have access to for moving it, so.
Yeah, as long as we're in compliance by January 1st, and we will be. And, you know, when we talk about drafting language, so presumably, are we talking about drafting language, one question for both documents? Is that what we're talking about?
And it was just
Or,
replacing the language on B, on the law school declaration.
Oh,
So we
okay.
more so mirror the application itself right now.
How do you start with that?
okay. I was just gonna say, because if a decision is being made, you know, the two questions are quite different.
Right.
The one clearly here is much broader, I mean, any arrest, and on the other one is just convictions essentially. And it's, you know, I don't know if that's like a policy question that needs to go to the CBE, or if we can just change it. I leave that to the ones who know.
I believe all the sets of changes are gonna come to the CBE as a formal packet of recommendation of suggested changes.
Great.
So even changing number 1B here, we'd have to wait till the CB decides in April?
Well, I know that 1G we have to do by January, so that will definitely get changed, because then we'll be out of compliance. And I mean, this seems like a B would almost be the same thing. If our intent is really to get at convictions rather than arrests, then I think we should just make that change now. I mean, I don't know why we're collecting this at the moment.
And that's something we can confirm with general counsel afterwards and let the working group know.
It's more of a correction than it is like a modification. So I think we'll consult with OGC, but it makes sense to make that change all at once.
Oh, because the application reflects more current thinking and changes, got it.
So if there's something else on the law school declaration itself, were there any other proposed changes to the actual moral character application? I apologize, I think there was one somebody else had at the last meeting and I couldn't find my note on which question that was, but now's our opportunity to go through it as a group and see if there are any other suggested changes that we'd like to make.
So this is not necessarily a change to the application itself, but I believe that Judge Torrealba suggested on the matrix, including a reference to which questions on the application were relevant.
Right, matching.
Just food for thought. I think that came up in the past.
And also on the application, I think it's page 32, think the judge will correct me, but I think you're adjudicated as a juvenile, you're not convicted. So question number 42 and question number 44 should probably say, were you adjudicated as a juvenile misdemeanor, not convicted?
When the matrix is finalized, it'll, be posted on the website, it'll be part of the sort of the package of what people see when they decide they're gonna go through the moral character process.
So definitely post it to the website, and that's where most things are going through now, but to be ADA compliant, we do also have the hard copy, we keep it as a packet, so we'd have it on the back of that, so.
So it's something that people will look at as a matter of course.
Mhm.
Do the committee want more time to respond to this? Should we put this on the next agenda as well, or do you think we're comfortable with it now? Okay. Anything else on this one? We're moving faster than usual, which is good. So I'll get out early, catch your trains and buses and planes home early. The last item on the agenda then would be 2D, determination of the next step, and future topic in the next two meetings. We have a meeting on January 23rd and a meeting on February 20th. Both meetings, as I recall, are in San Francisco. Right?
Yes. So I think hopefully by the next meeting, if you can talk with your respective group members, and we can try to finalize the matrices at the next meeting. I think like we discussed earlier, we'll go back and revisit the statement and guidelines. We'll put all of the draft language we'll send it to you beforehand, so that way you can take a look at it and see what you think needs to be in there. It may be that some of the paragraphs, the proposed language is not necessary now with the matrices themselves. And it may be that some need to be beefed up a bit. So if we can do that, and we'll go back and revisit the suggested law school best practices. So at this point, we're just trying to, I think, finish everything up to make sure that we have our recommendations ready to go. Let's see, here we go. So our target committee of bar examiners meeting will be April, and so Jim will actually not be attending that one. So hopefully Larry or Judge Torrialba, one of you will be present and be able to help speak to the committee on that. And then supposing that the committee of bar examiners does approve everything, then it would move to the board of trustees. So what we are planning on doing as well is after the work is finalized in February of the working group, we're gonna send it out to the committee members beforehand. So that way, like we're sending you materials out in between meetings, giving them a chance to review it, make any revisions. That way, hopefully we can get the approval in April, so.
Are those meetings open to,
So part of the meeting is
members?
open, but this, I'm assuming this would be in the open session since everything we're doing is an open session. Yep.
The meeting on January, and this group's meeting starts at 11:30, not at 10:30. I noticed the start time was.
Yes, the January start time is 11:30, and I might have a small presentation with the law school that morning, so.
And Debbie, just to be clear, it is often the case that there's an open part of the meeting and a closed part of the meeting.
Okay.
But it sounds like this would be likely included in
The open part's usually the first part of the meeting, closed is at the end.
and maybe it's on the website, so I apologize for asking, are those dates already announced? And do you know what those dates are?
Yes, I don't have them off the top of my head, but what we can do is we can have Ezra follow up and send the dates, the location, and everything, so that way if anybody from the working group would like to attend, you're more than welcome to, so.
And you're referring to the April CBE meeting and the
Board of Trustees meeting. Yeah, I'm just curious, like, what kind of discussion comes up regarding.
And
Do we have
The April meeting of the CBE is the 24th, it's a Friday, and it's here.
And the board meeting is on May 14th, and that is, I'll tell you where, Los Angeles.
I think you can sign up for, if you're so inclined, for email notifications and when they release the materials and stuff. Maybe you don't want more email.
I do.
Oh, okay.
And
I'm
there
not
are
a skate park
webcasts.
junkie.
There are webcasts, so that if you can't make it, you can watch the webcast.
Thank you.
Over and over and over.
Thank you,
till
everyone.
you sleep.
Think I'm
Okay, is there anything else anybody wants to cover today? Thank you all for coming. If not, then I'm going to adjourn and we'll see you all in January. Yeah.